Good evening. I'm Melanie Risdon with the Western Standard. Joining me tonight is Katherine Kowalchuk. She is a Calgary lawyer with Getz, Collins and Associates. She's also a lawyer with Lawyers for Truth. And we're talking with Katherine tonight because we did have a chat with Katherine about a month or two ago. And Katherine was representing a client who was seeking to have his children, not vaccinated. That court case turned out very differently from one that was just settled in an Ontario court on Tuesday. So we thought we would chat with Katherine a little bit about this new ruling and just get some insight from her as a lawyer and look at some comparisons to the court case that she dealt with. So thanks for joining us, Katherine.
Thanks, Melanie, for having me.
So this is a very interesting ruling. I have read through the judge's entire judgment on this, and it's incredible. Why don't you fill us in a little bit?
Yeah, it is incredible. I first received this morning, and right from the get-go, I was pleasantly surprised by the questions that this justice was asking. In particular, all of them were great throughout the judgment, but let's just focus on a few of them, if you would. On the first page, at line 5, paragraph 5, the justice talks about misinformation, and is this even a real word, he says, or has it become a crass, self-serving tool to preempt scrutiny and discredit your opponent, to delegitimize questions and strategically avoid giving answers? Blanket denials are almost never acceptable in our adversarial system. Each party always has the onus to prove their case, and yet misinformation, in quotes, has crept into the court lexicon. Other questions that I like in his ruling include on paragraph 20 on page 5, at subparagraph D, he says, can you simply utter the words conspiracy theorists and do a mic drop? Those are two instances of very good questions in this ruling that I think we've been lacking for 2 years, not only in our courts, but in public discourse and with our politicians. And so it is a refreshing decision. It seems to me to be very reasonable, very logical, and it highlights very good points that other justices across Canada have simply ignored or disregarded in their rulings. And one of the things that this case highlights is the importance of having the decisions voices with respect to these healthcare decisions. And the justice talks about that, and I'm happy to see that because we all have bodily autonomy, and our children may be little, but they are important, and their voices in this are integral. Unfortunately, we're not all able to get informed consent because we know that the information has been lacking. It's been sparse. People who have questioned the narrative of the efficacy of the vaccines have been canceled or vilified in the media and amongst peers and colleagues, families and friends. And the other thing that this case highlights, which is great, is the justice's review of judicial notice. What I also think what is great about this is that a self-represented party, the mom, presented this to this court, and I just love the fact that she is self-represented.
So she didn't even have a lawyer representing
no,
her.
she
Oh,
conducted.
wow.
It would seem by this judgment to be very professional, and the judge was obviously persuaded by the information and the evidence that she provided, which is set out in this judgment for everybody to read. And I encourage everybody to read it because these are really good points that he brings out. But he makes the point. Judicial notice has been something that these justices across Canada and Alberta, and certainly in my case, that they've relied upon in making their rulings with respect to these COVID mandates. right from the Court of Queen's Bench in Manitoba, Ontario, BC, and Alberta, and others, in Saskatchewan as well. So, and what judicial notice is that something is so notoriously known that basically you don't need to provide any evidence of the fact that it exists, right? And we've had a lot of problems with this notion because obviously the information and the evidence has been lacking from the governments. And it seems just to be something that is just, well, you better take us at our word, and then that's the end of the conversation. Of course, that's not the end of the conversation. And what I like about, I'm sorry, I'm just flipping through the ruling right now, but what I
Hmm.
like about this ruling at page 19, paragraph 59, is that you'll see at 58 and 59, is that the justice clearly states that, judicial notice cannot be taken of expert opinion evidence. And he goes on to distinguish this, what is a fact in what is an opinion. And he basically likens what the government has determined to be safe and effective as an opinion. Therefore, it's inappropriate to take judicial notice. Therefore, it's incumbent upon these governments and parties relying on this COVID narrative that they have to provide expert evidence. They have to provide legitimate evidence to support their position. And I really like, he says it in the middle of the paragraph 59. A statement concerning the safety and efficacy of any medications in the prevention or treatment of any condition is in and of itself an opinion. Judicial notice cannot be taken of the opinion of any expert or government official that a medical treatment is safe and effective. That's a
Hmm.
mic drop. Maybe that's a mic drop. Um, so I think that it's welcome news, not only in the area of family law, of course, because this is a very contentious issue, but this is, I'm sure, all the other lawyers who have been bringing these court challenges across the country will find this case particularly welcome.
And to talk about these cases, I mean, I have to understand, and you've been through it. You've supported a client through this. It's a difficult place to be in when you are talking about two parents who have very differing views on specifically a medical treatment for, like you said, children, children who are typically not looked on to have to make their own decisions and make these calls for themselves, right? And of course, we as parents, we're always working in the best interest of what we believe is right for our children and is in their best interest. But the fact that these two parents come to head on this discussion has got to be very hard to begin with. And as a judge trying to discern, what I appreciate about this judge's ruling is that that he went into depth with the children as well, spoke to the children, and we're not talking very, very young children. I believe they were around 10, 12 years old in
I believe
in
so.
this case.
Yeah.
Yeah, so we're not talking 3, 4, 5 year olds, but the interesting thing that I found with this justice is that the children were asked, what do you feel, what do you want? And they said unequivocally, one of the children spoke unequivocally and said they wanted the justice to know and understand. They had a great fear of getting this injection, and to ignore that and rule in a parent's favor to allow the parent to have the child injected, this justice said, I believe that would cause quite a bit of emotional harm to the child. I think that's an important thing to be weighing here as well.
Well, it is very important. But the test in family law with respect to these issues is what is in the best interest of the child. And, it's set out in our legislation in the Divorce Act, for instance. And so really, what this judge has said in this ruling is very important. Not only do the children's voice matter, but it underpins a bigger problem that we've all been facing the past few years in particular, that if you have a different opinion than the government or than the media, then you're automatically some sort of crackpot conspiracy theorist, anti-vaxxer nutcase. And
That's
that's
right.
simply not the case. And what's nice and refreshing about this judgment as well is that he looked at the mom's evidence. And in family law it's difficult because in these sorts of applications, not there's not necessarily expert evidence that you would typically have in maybe a longer trial, for instance, or witness testimony. So the information provided was by way of affidavit. And you know and so hiring experts is expensive, et cetera, and there's not the opportunity in these cases to do a cross-examination of these experts. Nonetheless, the judge makes the point that yes, it's up to the justice or the judge hearing the matter to decide whether or not it's material and relevant, the information that was provided. And in this case, the justice was very mindful and considerate of the information that the mom was providing, which is contrary to what the government narrative is. And that's important because that that alone in and of itself highlights the point that this issue is not settled and so notoriously known as to be able to decide definitively that the COVID-19 is safe and effective. Not only that, he also makes the point that this we cannot, and I don't think he says this directly, but is implied, we cannot um, broadly base this sort of policy to apply to all children when the test that the court goes through is what is in the best interest of this particular child.
That's right. And so for this case particularly, just to highlight it, and I will have sort of some points from the judgment on the story on the website for you to, and I will also have a link to the full judgment for people to read for themselves. And I highly recommend you do, because I really appreciate the full picture that this judge paints of this kind of situation that we're facing in Canada and across the world. But this is two parents. This is a mother and a father who have three children. The mother is sort of primary guardian or has primary custody of two of the younger children, where the father has primary care for an older child. Now, the older child said they wanted to get vaccinated and did. But the younger children who are under the mother's care did not want to get vaccinated, nor did the mother want them to get vaccinated. And that's where the sort of fight ensued, was the father was really pushing. And like you said, the father brought, according to all of the notes from the judgment here, the justice does a really good job of really showing what his assessment was of everything. The father brought, like you said, websites from the government, CDC, things like that, to argue his point that this is what's in the best interest of my children. But the mother also brought what the justice said was very credible information, that wasn't something that he could just discredit. And one of the documents that she used was Pfizer's own adverse events report that has been circulating now for a few months, that shows there are a number of possible side effects or issues that a person can face from these, including, everything from an allergic reaction to myocarditis and some of the other risks associated. The mother said in her argument that she didn't believe that the children were at a very great risk from COVID itself, and therefore the risk of the vaccination potentially was greater than the risk of COVID, the actual disease, for the children. And what I appreciated was that the justice sort of took time to map out how the father really then just chose to try to vilify and cancel her and her assessment by bringing forward a whole bunch of social media posts that she had, tying her affiliation to the People's Party of Canada and what the People's Party of Canada's opinion is on the vaccine mandates and whatnot, and sort of chose to try to socially discredit her in the court's eye. That I found, for him to call that out, I found very interesting.
Well, it's actually great that he did so because, with the rulings to date, up until this case in Canada, that's exactly what we were hearing from these justices. When we talked about the case where I represented the dad who didn't want to have his children vaccinated yet, he wanted the court to wait. He wanted the court to decide to wait for further information. He wasn't an anti-vaxxer, and his children, had previous vaccinations, and really the evidence that we had put forward was, look, there are some serious concerns that have come to light from multiple people, experts, disciplines, saying that this is not there, and even the own government information, which is also set out in this judgment, that highlights, well, there is risk. And so it's very dangerous where our society has gone with this issue, because people simply want to have the information, and they want to be able to decide for themselves what to put into their body. And this is a long-standing principle. It dates back for a long time, including the Nuremberg Code, which required informed consent, required you can't experiment on a population or any person without their consent, and so instead of and so when people embrace this sort of value system, which I think is a great value system to ascribe to, these people are vilified because they simply have taken a different point of view. And then the cancel culture of our time just will say these buzzwords such as conspiracy theorist and anti-vaxxer, and then it effectively is a mic drop. And it's astonishing that those sorts of inflammatory, unhelpful statements can be used to discredit people who have legitimate concerns about what has gone on, what are in these vaccines, what are the true side effects. And it really should be up to the individual person to weigh the risk for themselves. The information published by these pharmaceutical companies and the governments, they all speak to there is a risk. Now, they've categorized it as there's a minimum risk or whatever. But in this climate right now, we're not even allowed to have a fulsome conversation with our doctor, because the colleges of physician and surgeons across the country, basically put a gag order on all doctors, and you can't get an exemption. So there's no wonder that there's people's spidey senses, of course, ring when they're being forced to do something when there's clearly a different opinion about what is going on and whether or not these vaccines are safe and effective.
Well, and it's interesting too that you mentioned that, because some of the first communications in this judgment from the justice say, when did it become illegal to ask questions, especially in the courtroom? The second thing he says is, and when did it become unfashionable for judges to receive answers, especially when children's lives are at stake? Those are big questions for a justice to feel the need to ask at this stage of the game, and I'm glad he did. How did we lower our guard and let the words unacceptable beliefs get paired together? This is in the very first words out of his mouth. Should judges
Yeah.
sit back as the concept of judicial notice gets hijacked from a rule of evidence to a substitute for evidence? Like, it's, these are really paramount. And again, I'm going to recommend. I've put together a bit of a summary on the website, but I do also have a link on our website as well to the full ruling. And it seems very candid. This ruling is very candid, and is it normal? Is seeing a judge communicate like this in a ruling, in a judgment, is that normal?
Well, I certainly, I don't know if it would be normal, but certainly judges do, have been known, I think, I can't point to a specific case off the top of my head right now, but to weigh in on and provide their perspective on
Hmm.
things. And I think that this is what you see in this judgment here, that these questions, I mean, quite often we all have our own opinions about things, but what I like about this approach is that these questions are designed to get people to reconsider or think about these questions, from a point that perhaps they had not considered before, and maybe just relied too much on mainstream media and government rhetoric.
Well, and looking at line 17 and 18, sort of, this is where the justice is talking a little bit about the evidence that's been provided. And he points out that the mother's evidence focused entirely on the medical and scientific issues. And this is where he points out, in contrast, the father focused extensively on labeling and discrediting the mother as a person in a dismissive attempt to argue that her views aren't worthy of consideration. I mean,
Yeah.
and then he goes into sort of itemizing a few things here on uh, talking about this being an odious trend, rapidly corrupting modern social discourse, ridicule and stigmatizing your opponent as a person rather than dealing with the ideas they want to talk about. It seems to be working for politicians, he says. I mean, this is almost like a snapshot of where our society has gone, and he's just calling it out.
Yeah, he nails it, and I think it's something that we've been waiting for. I know as a lawyer, um, it's been 2 long years of reading judgments, obviously that haven't gone in the favor of people, who are fighting these mandates, and so this is a breath of fresh air to hear a justice come out, ask these questions, and make this commentary, about the state of our world. And I think that he is bang on. We've become a society where privately and in public, people are so afraid to have a conversation because they don't want to say the wrong thing or get canceled, because the woke culture is so fast to jump on people, and instead of debating the ideas, they attack the person, and
Right.
that's just the um, um, go-to strategy for this entire group of people. And you contrast this with my case that I argued last year for the dad, and my client, because he just wanted to wait and see, notwithstanding, we provided very good evidence, from a myriad of sources, including government sources, in pointing out the fact that the own government's information notes that there are risks to receiving this COVID-19 vaccination. And it didn't matter, like the same document that said it was safe and effective also said that there were risks. And so it was almost a cherry picking, and it has been a cherry picking of which of the evidence suits the narrative. And the mass hysteria of the COVID fear has clearly impacted, people's perceptions, people's um, uh, ability to have logical opinions that may differ from other people, and as a result of what occurred in my case, my client, was obviously denied any decision making with respect to the COVID-19 vaccination for his children, and also was denied all healthcare decision making authority ultimately with respect to the children, based on the premise that he was an anti-vaxxer or conspiracy theorist.
Right.
It is deflating. And what the courts, up until this ruling, seem to have lost all humanity. Like, these are real people, and these children's lives do all matter, and their voices matter as well, and they all too deserve to have as much information as possible, and the right to say, no, this does not get to be put in my body, and or I want to wait until further evidence is available before I agree to something like this.
Well, and especially for the children's sake, simply because there was a significant amount of data and study already coming out with regard to vaccinating adults, but it was a very short, and it seemed to me a very small study for the outcome of vaccinating children. And so, I could understand a parent's desire to want to wait and just wait and see what any sort of
Mhm.
longer term effects might be. So you're right. I feel like there was, well, and I recall when we were discussing your case, the verbiage, the sort of the narrative from the justice in your case versus this one, polar opposite, just very different. Can you
Well,
speak to
and
that a little bit?
Well, it is, but that's what we were hearing across the country, because that's what the mainstream media and government was saying, and it was almost like this sort of anger, that animosity towards other people who had taken the time to do other research that wasn't just provided by CBC or on the Health Canada website or the Government of Alberta website. They did a little bit more digging and then found some really good information. Like, some of the information that we presented was from the American College of Physicians and Surgeons, which did speak to the Pfizer study with respect to whether or not um, it was big enough, and and and
Like as
and
far as the
did,
study,
in terms of the participants in the study,
right?
and also said, it was too small of a study. The children were only followed for 2 months, and then basically, it was approved in Canada. And notwithstanding that, there were clearly signs where the own government information said, further studies are ongoing because we do not know the long-term effects of this. I
Hmm.
mean, so for anybody, including a justice, just to take the government at its word. And what the other good thing about this ruling is that the justice talks about the many instances in our history where the government's got it wrong.
Mm.
You
Yeah, that
know,
I did notice that too, kind of further down in the document. There were a lot of cases that this justice cited and pointed to, saying we can't just always assume that what the government is communicating is, gospel, is
well,
absolutely bang on right.
exactly. At page 20, was it page? Yeah, he discussed uh, paragraph 67. Why should we be so reluctant to take judicial notice that the government is always right? And he talks about residential school systems. For decades, the government's assured us that taking the Indigenous children away, and being willfully blind to their abuse, was the right thing to do.
What
We're
line are you
still,
on? We'll just make sure we're
sorry,
on the right line.
paragraph 67 sub B.
Okay.
You know, we're still finding children's bodies. How about sterilizing Eskimo women? The same thing. The government knew best. D. Japanese and Chinese internment camps during World War II. The government told us it was an emergency and had to be done. Emergencies can be used by governments to justify a lot of things that later turn out to be wrong. How
Hmm.
about thalidomide? It was experimental drug approved by Canada and countries throughout the world in the late 1950s. was supposed to treat cancer and some skin conditions. Instead, it caused these birth defects and dead babies. And he goes on and on. Like, and look at how many other experts. Your doctor used to recommend that smoking a pack of cigarettes wouldn't be dangerous to your health.
Good for stress, right? Yeah,
Exactly.
exactly.
We used to use cocaine in our food products. So
And our cough syrups, yeah.
exactly, right? So the hysteria, the fear mongering, and the government did a really good job of it, and the media helped them, right? There was one narrative, and that was the only thing that was going to be played on the TV and in your radios, on social media, 24/7, and it did a really good job at convincing people that that believing anything different than what the government said um, was just wrong. And, we've seen in the past couple of weeks specifically with Justin Trudeau's invoking of the Emergencies Act and then and then canceling that, 2 days
Within
after
2 days, yeah.
like, you know, it is anybody who's a logical, critical thinker must be scratching their head right now saying, what just happened? And you know what? The ramifications of that little exercise, temper tantrum that the prime minister has gone through and put us all Canadians through, allowed for significant changes to our banking and finance system, which allowed that must be dealt with. I mean,
And
this
it
is
looks
far.
like it looks like they're planning to try to keep those. I mean, to be honest with you, I've been given a kind of an update for RBC, and it is an update on their policy and how the wording for certain policy is changing, and it seems to be tied to this. It's a very recent change to their wording where they can now discern whether they're going to drop your credit based on more than just your sort of credit activity or your banking activity. They can base it on whether you're somehow a threat to them or you're somehow going to,
Yeah.
it seems like they're looking at this social, what are you doing socially that could affect your credit rating? And it looks like they're implementing this stuff now.
Yeah, these conspiracy theories, like the social credit system being brought to Canada, aren't necessarily theories anymore. We're seeing it play out in real time. And we should all be concerned about that as citizens because, I mean, just because I have a different opinion from you, does that mean that shouldn't be able to access my bank account? And that's effectively what the federal government has done. And you know what? I haven't heard of any provincial premier or any other MLA or MP, except for perhaps a few in the conservative ranks, speak out against this. It is dangerous, and it must be dealt with. And
Hmm.
hopefully this will be challenged in the courtrooms, and or upon reelection, the new politicians then will see fit to change this dark period of our history.
Well, and some of the other comments that I wanted to just highlight from this justice's ruling here that stood out to me. We'll go to line 20 in the ruling. This is after he has sort of the justice has gone over some of the ways that the father had tried to sort of vilify or discredit the mother. Uh, and the first thing he says after that is, how is any of this relevant? He says, have we reached the stage where parental rights are going to be decided based on what political party you belong to? Is being seen with Maxime Bernier or anyone for that matter the kiss of death as far as your court case is concerned? I mean, this language is really interesting and powerful when we're talking about, later in the ruling. He basically lays out what the courts are here for. What we're
Mhm.
not. He lays it out. I am not here to judge whether this vaccine is safe or not. I am not here to judge whether these parents are good parents or not. And sort of gets to the root of it. I am here to contribute to the decision of what is in the best interest of these children. And it is refreshing to see a judgment that seems to more so take on a rational view and a realistic view from both points, right? From both sides, not discrediting one side right off the hop, and coming at it, like I remember with your case, coming at it with this idea of, well, of course this is in the best interest of the children because this is what the government says we need to do to be safe.
Well, let's just think about this practically in the timeline, okay? So last fall, we have these mandates kind of roll out across the country that you need to have this vaccine by a certain date, or you're going to be fired. People who are vax-free aren't able to travel internationally within Canada. We can't get on a plane, for instance. There's court challenges with that. And so this thing plays out. The government, pushes and then extends deadlines, basically scares all private companies and business to follow suit. And in implementing these vaccination policies across their board, they fire employees as a result. They change the structure of what their office looks like. And so this started to occur in October, November. And then we have all of a sudden in February that they're done. In Alberta, that Jason Kenney says, okay, we're not going to have these vaccine passports anymore. Wow. I mean, if I was a business in Alberta that had to jump through all of these hoops, fire really good employees and contractors because of these government mandates, and now they're not required any longer. I mean,
Or how about the businesses that had to shut their doors for good?
Well, exactly.
More so than the ones that had to, jump hoops, but lost everything.
Well, exactly. And some of the, some of the things that were mandatory, people, I guess, were thinking were going to last forever. And now they're not mandatory. Although Jason Kenney has made it very clear that businesses can make their own discriminatory practices and policies as they see fit. And then I put the question out to the public, based on what? If the government has sought fit to remove these mandates, upon which basis are they relying to continue these sort of discriminatory practices in their own companies and in schools or wherever they may continue? Because allowing companies to do this, in my opinion, is just simply wrong, and it sets a dangerous precedent. And in fact, what the government has done in Alberta, for instance, by allowing these businesses and other institutions to continue mandates such as this as they see fit, it is going to continue to divide our population, and it is in fact promoting discrimination. And for these people who claim that equity, inclusivity, and diversity is all about getting to the root of systemic racism, well, they're not doing a really good job living by their own principles, because in fact what they're doing is advocating discrimination.
Mm-hmm. One thing I wanted to point out too, at the very end of the ruling or the judgment from the justice, the postscript, I found that interesting and worthwhile mentioning here. He says, it's irrelevant to my decision and it's none of anyone's business, but I am fully vaccinated, my choice. I mention this because I am acutely aware of how polarized the world has become. We should all return to discussing the issues rather than making presumptions about one another. I really respect that sort of final statement, because I think it does it does give a little bit more context to people. This isn't, a judge who somebody can just turn around and say, well, anti-vax judge would of course rule like this. We can't say that now. So I actually really do appreciate, although it was no one's business, I really do appreciate that he included that.
Yeah, it is nice. It is nice because it really just throws water on the fire on the anti-vax fire narrative, right? Because this has never been about the vaccine. It's always been about personal choice, and the left and the media have done such a great, and our governments have done such a great job to try to convince people that like I said earlier, that you're some sort of crazy crackpot whack job if you have a different opinion. But this has always been about choice and about personal freedoms, and I think what this judge highlights for everybody is that we have veered far off course in many areas, not just in our courts, but in many other areas of our society. And it's about time that we all level up and start having the conversations about the issues and stop attacking people for their opinions and what it is that they believe, and that we respect other people's rights to have an opinion and to voice it, and that we are entitled to full disclosure from our governments. Our governments work for us, and that. It's not trite. It's very important that we as a society get this, because we've developed into a society, in my opinion, where we look to the government as some sort of parental figure to tell us when it's right and wrong to do whatever in our lives. And that, in my opinion, is just wrong. They are there as a utility for the citizens in which they are elected to govern. They are to implement the voice and the will of the people. And they have failed miserably. And if anything, the truckers' convoy has highlighted that in like neon lights, for the world to see exactly what happens when we bestow all of our faith, all of our decision making abilities with these governments.
Hmm. One last question before I let you go, Catherine, is do you see this ruling, this judgment, as precedent setting? I mean, because I understand that's how a lot of laws are judged, is based on other rulings.
Well, it is. It will form part of the precedents, particularly so in Ontario, for other justices to consider when they're being when they're faced with a similar fact scenario, and this becomes relevant. In other provinces typically look to their own jurisdiction's rulings first, but clearly consider other cases that are decided in Canada and even throughout the world. I mean, it's about being the trier of fact as a judge, and you look at all of the evidence presented, and you look at whether or not what sort of weight should be attributed to the evidence presented, and then you make your decision based on the totality of evidence and as it applies to that particular fact scenario. And so I am hopeful, and maybe this will allow other justices who have been silent, maybe also thinking the same thing, but haven't had the opportunity to have a case where they're able to decide something like this in this manner. But maybe this will give them the courage that they maybe didn't have also in future rulings. And maybe this is a commentary that again, the people are rising up. We are becoming more and more wise to these antics, tyrannical antics, and this division that the governments are causing, and the tide is changing. And so I think it's very astute for this justice, whether or not he felt this way all along or not, that he had enough courage to come and present this judgment in the manner that he did.
Well, it is an impressive judgment, a lengthy one, and definitely, like I say, well worth looking into and reading. Again, I've got a highlight of some of the judgment on the website, as well as a link to the full judgment. Katherine Kowalchuk, thank you so much for joining us. Again, with Getz, Collins and Associates. She's a Calgary lawyer and also works for Lawyers for Truth. Thank you so much for your assessment of this judgment, and we will keep in touch and I guess watch how this may start affecting things down the line.
Great. Thank you, Melanie, for having me today.
Getz is owned by Algonaut. This is great new technology just coming online now in the digital currency world. Getz is a great way for you to use the digital currency Algorand in your day-to-day transactions. Can you imagine a world where we don't have to buy a cup of coffee using the federal dollar, and you don't even have to use the American federal dollar? You don't have to use the euro or the pound sterling. You can use real money, digital currencies that are not at the beck and call of governments and inflation. Getz is making digital currencies usable in a day-to-day basis.